The second case on this morning's docket, it is case number 104115, State of Kansas v. Robert Stevenson.
Good morning. My name is Rick Kittle. I represent the appellant, Mr. Stevenson, and Your Honor, I'd like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. This case presents the question of whether the odor of alcohol emanating from the interior of a vehicle standing alone provides probable cause to search the interior of the vehicle, to conduct a warrantless search. In this case, Mr. Stevenson...
The way the Court of Appeals teed it up, it's a little more than that. Does the odor of alcohol emanating, a very strong odor of alcohol emanating from inside a vehicle after the driver or sole occupant has been excluded as the source of that smell?
That's true.
Isn't that basically what they said?
That's true. And both the Court of Appeals and the District Court relied upon the Bickerstaff case. But I think there's a little irony in both of those courts relying on Bickerstaff, because one thing that I think universally the cases that have touched upon this issue have taught us is that you need to look at the totality of the circumstances in these cases to determine if the odor of the substance coming from the interior of the vehicle provides probable cause. In Bickerstaff, we have a situation where, well, taking the totality of the circumstances into consideration, in Bickerstaff you have a situation where there was erratic driving observed, you have the odor of alcohol being on the person of the driver, and that's the main irony here, because although the courts below here relied upon Bickerstaff where there was an odor of alcohol coming from the person of the driver, in this case there was none. Mr. Stevenson was removed from the vehicle. Apparently at that point the officers realized that they couldn't detect any odor of alcohol coming from his person, but they still smelled alcohol coming from the interior of the vehicle.
And the irony is that in Bickerstaff, the court found that because the driver had been drinking, that supports probable cause. And here they said because the driver had not been drinking, that supports probable cause. Right. Akin to the I-70 messy car, clean car, both support probable cause.
Right, right. I mean, in one case, the odor of alcohol on the person of the driver is incriminating. In our case, it is. In the other case, it's not.
Well, I see that.
No, go ahead.
Go ahead. You were.
I see the argument both ways. If the driver's been drinking, that makes it more probable than not that an open drink is in the car. If the driver has not been drinking, it makes it more probable that it comes from inside rather than from the driver. So there's arguments to be made in both scenarios.
I suppose that's true, but if you're actually going to look at the totality of the circumstances, I think you have to examine what has been part of the totality of the circumstances in other cases. In prior cases, we've looked at, was erratic driving observed? We've looked at the fact of whether of the behavior and the appearance of the driver. Was he disheveled? Was he glassy-eyed? Did he have slurred speech? And all of those factors. What was his performance on field sobriety tests, if there were any? Were there any incriminating statements made by the driver or other occupants of the car? In this case, we have none of that. We have no plain view observation of any bottles.
Let me just back up here. Why transporting an open container is illegal in this state, and why isn't the strong odor of alcohol emanating from the vehicle supply an officer with probable cause to search? Okay. Just that fact alone. Okay. And it's a strong odor that not coming from anywhere else but the vehicle.
Because I would challenge your first.
All right, go ahead.
First premise. It's not. First of all, alcohol is a legal substance.
Correct.
It's legal to sell it, to purchase it,
drink it,
to consume it. It's not absolutely illegal to have alcohol in one's automobile. In fact, under the statute,
an open container
statute, it's not absolutely illegal to have an open container within the interior of a vehicle, so long as it's a car that is not equipped with a trunk. The open container can be kept behind the last fixed row of seats. In this case, we're talking about a Chevy Blazer, which is an SUV. It doesn't have a trunk. And so in this case, it would have been legal for Mr. Stevenson to have an open container of alcohol if it was behind the last fixed row of seats. And there's no way that the officers could have known, one, whether there was actually a container in the car or whether it was just something spilled on the floorboard. And even if there was a container in the car, there was no way the officers could have known that that was not legally behind the last row of seats in this vehicle.
But their burden is not to know. Their burden is to have probable cause. And if they're standing at the driver's window and have a very strong odor, why does that not give them probable cause that there's an open container of alcohol
Because,
sufficient for them to
excuse me.
investigate to determine whether or not that's back in the clear at the back of the vehicle or by the driver?
Because in this state, according to the law that I believe has the most application here and the most precedential value, which is the Ibarra case, which also talks about a legal substance. In Ibarra, this case held the odor of alcohol standing alone, even after the driver and any objects that had been removed from the car that might have provided the odor of ether. This court found that the odor of ether standing alone did not provide probable cause to search the vehicle.
But isn't
Not
there,
it's not illegal to
That's-
transport it in an open container in your car, right?
But it's not absolutely illegal to transport alcohol in an open
I
container.
think you're missing the practical argument here. The open container means that the seal's been broken.
True.
And if you have a bottle that if Mr. Stevenson had consumed half of that bottle of red wine, firmly replaced the lid and set it on the seat, there would have been no odor of alcohol coming from within, because here the strong odor of alcohol came from the spilled container.
Okay.
And I don't think it's unlawful to transport spilled alcohol.
It's
It
not.
says, transporting an open container, so I think it's a factual matter. The officers here testified that they thought the alcohol had been spilled.
Right. But they didn't know, and I realize this is not an absolute knowledge question, but you could have the presence of spilled alcohol in the car without there being any container. I have an SUV. Occasionally I have to take glass to a recycling place. So if I have wine bottles or beer bottles or whatever kind of glass containers, I put them in a container in the back of my SUV. There still may be contents in those bottles.
Your better policy argument is the designated driver that
Well-
has passengers that spill and cleans out the car, but still takes the people home.
Well, I'm not talking about that. I'm talking about at some point you have to dispose of that glass. You have to carry it in a vehicle, and the law provides for that. And if we're going to take the totality of the circumstances into consideration here, you have to consider the type of vehicle that's involved, because the statute specifically provides for consideration of the type of vehicle involved. So that's not a stretch.
Mr. Kittle, would you agree that maybe the odor of alcohol emanating from the vehicle and the exclusion of the driver might have given these officers, after resolving the reasons for the stop, a continued or an additional reason to continue the investigation, a new reasonable suspicion, if you would call it that, as opposed to probable cause to search the vehicle? It might have allowed them to ask questions. Hey, we can smell this from your vehicle. What's going on? To develop the probable cause, but it wasn't standing alone, I think, is your argument. Could you make a distinction between reasonable suspicion
Well,
and
sure,
probable cause?
sure, I
here?
would, and I think that's generally recognized anyway.
Right.
But
But I mean,
these
as a new basis, because that's not what he was stopped for. But then they smell the odor of alcohol from the vehicle,
Right,
But they
consider
rule
the
out
facts.
some other basis. That doesn't necessarily mean they don't have reasonable suspicion to continue asking him questions about that odor, but not necessarily to search the vehicle.
And I think that brings up the good point. It's the state's obligation to produce evidence to show that the officers acted within the law. The sequence of events here is they stop the car. There's two officers. They go to either side of the suspect car. The driver's side, they smell alcohol. They get Mr. Stevenson out, take him to the rear of the car. They perform field sobriety tests. Negative. They don't smell any alcohol in his person. I would argue that that's not an incriminating factor. It's an exculpatory factor. They put him back in the car, and they go to their patrol vehicle where they check his license and registration. Nothing, no problem there. They discuss what they're going to do, so they go back up to the car. They get him out again. And after all of that, which I would argue is what they've done for further investigation, they then do the search without any probable cause. Now, they didn't ask, at least there's no evidence in the record that they ever asked him about consumption of alcohol. There's no evidence in the record that they saw any container within plain view. There's no evidence that they asked him anything about the odor that they detected. And so there's no incriminating statements. There's just no other factors here that have a bearing on the question that are incriminating.
That was basically Judge Boozer's dissent.
Well, that was part of it, yes.
Yes, that gave them reasonable suspicion to investigate further, and they should have at least shined the light in to see that the wine bottle that was laying on the seat, or they should have asked the driver, do you have alcohol in the car, or instead of jumping right to the search, they should have continued their investigation. Is what his argument was.
It is, and but it's the state's obligation to produce that evidence. You know, I don't know whether they looked in there with a flashlight or not, but they certainly didn't indicate that they did. I don't know if they asked Mr. Stevenson, have you been drinking, or can you explain the odor of alcohol coming from where we detect coming from your car? But there's no evidence that the officers did that. But they did do some investigation based upon the odor of alcohol. They gave him field sobriety tests. They checked his license. They obviously observed him to see if he was disheveled, whether he had glassy eyes, slurred speech, balance problems. None of those things. All of the evidence here all of the evidence beyond the odor is exculpatory in nature. And if we take it all as exculpatory in nature, all we're left with is the odor of alcohol coming from the interior of a vehicle. And the one case that has dealt with the subject of a legal substance standing alone coming from the interior of a vehicle is the Ibarra case. And this court in Ibarra said that's not enough to provide probable cause. With ether, it would be illegal to carry ether in a vehicle if there were other incriminating circumstances. If you saw other items that were being used in the manufacture of methamphetamine, but he didn't have that here. The same thing is present here. The odor of alcohol standing alone is not enough to provide probable cause. I see my time has expired, so Mr. Chief Justice, that concludes my comments unless the court has other questions.
Do we have any further questions of counsel? Thank you, counsel.
Thank you.
May it please the court, Assistant District Attorney Leslie Isherwood, appearing on behalf of the state. The first, or pretty much the only issue before the court this morning, challenges the denial of the defendant's motion to suppress. At the time that that motion was heard before the district court, the evidence was that there was probable cause to search that vehicle for an open container following the deputy's testimony that they sensed a very, very strong odor of alcohol emanating from the vehicle compartment, that which was much stronger than what is typically present and associated with consumption. Upon making their initial contact with the defendant, the officers, both of them, immediately detected the odor. He was asked to exit the vehicle. At that point, there was no detection of an odor emanating from his person or on his breath, yet when he was returned to the vehicle, the odor was still present.
And that is the only factor we're dealing with here. There's nothing other factors that corroborate their suspicion or their probable cause finding other than the strong odor. Is that right?
Well, I think when we talk about factors and we talk about Bickerstaff and we talk about these other cases, the other factors that were present there are bloodshot watery eyes,
That's
or
a Bickerstaff.
right, or evidence of drinking.
Right.
What we have here are the absence of those factors, but those aren't any less factors because we still have the strong odor of alcohol. So they're eliminating a source, and those are exculpatory factors for, say, driving under the influence, but those aren't exculpatory factors for transporting an open container.
Now, we've said that probable cause is more a common sense determination rather than a mathematical formulation, have we not?
Well, it's a fluid concept, and you base probable cause based on what the officers in their training and experience are accustomed to and the inferences that can be drawn from that training and experience.
And why does the very strong odor of alcohol from within the vehicle indicate that there's an open container as opposed to spilled alcohol?
Because the statute says, if I can pull it up, that no person shall transport in any vehicle upon a highway or street or any alcoholic beverage unless such beverage is, first subsection, in the original unopened package or container, the seal of which has not been broken. And in this case, the officers testified the seal on that wine bottle had been broken. In order for it to leak, the seal has to be broken.
But ordinarily, that's true, but ordinarily when you have a seal's broken but the cap in place, you can't smell it. It's only when it's spilled. And these officers said that they thought there was spilled alcohol.
I believe the record reflects that they said that the odor was strong, so strong as I think they equate it with the smell of a spill, but I don't believe the officers testified we necessarily thought it was spilled, if that distinction makes.
Well,
I think there's
I was
big
going off
strength.
the district judge indicated that the officers had thought that there was a spill, but we can check that in the record. But back to my question is, are you saying it's illegal to transport spilled alcohol?
I'm saying it's illegal to transport, according to the statute, a vessel for alcohol where the seal has been broken. And that's what happened in this case. The matter is that
So we
the
have
container has
objective
been
probable
opened.
cause, they found it, so there must have been probable cause?
No. The
I'm
officers.
talking about the likelihood that you would have a bottle on the seat with the seal broken because you have a very strong odor. To me, that very strong odor indicates someone spilled a drink or spilled alcohol rather than you have a open container.
And this is where we defer to the experience of the officer and the smell of the odor, what that connotes to them, which is what the rationale derives from the marijuana cases, is that you look at the strength of the odor, speaks to the quantity, and what reasonable inferences can be drawn from that quantity. I'm not saying that spilled alcohol is illegal. What I'm saying is under the plain language of the statute, when that seal is broken, it's the transportation of the open container. And what happened in this case was the transportation of an open container. The probable cause is derived from the fact that the officers were able to eliminate the other sources of that odor, in that it was not present on the defendant, it was not emanating from the defendant, he was not intoxicated, but the odor is still present. They are not required to turn a blind eye to that simply because he doesn't smell like alcohol or he's not intoxicated.
The other way to view that from common experience, if you have the odor on the driver or sole occupant, you might suspect that there would be an open drink from which the driver was consuming. But if there's no odor of alcohol, then you probably can eliminate the fact that there's an open drink in the console as being the source of the alcohol. And if you eliminate that, then you're back to what I said earlier, whether you have a corked up bottle that you can't smell or whether there's been a spill within the car.
Well, and I guess, I guess you and I are going to have to agree to disagree, because from my perception and from my interpretation of the statute, it doesn't matter if the alcohol has spilled. What matters is that the seal has been broken and it's in the
matters if-
passenger compartment.
It matters if the alcohol spilled, but the bottle was not there. And what we have is, what did the officers think they were going to find? Did they think they were going to find a corked up bottle, or did they think they were going to find a bottle that was loose and spilled, or did they think they were going to find that a drink had been spilled in there earlier because the driver did not smell of alcohol?
They thought they were going to find an open container, but they don't know what they're going to find until they investigate and conduct a search. They, as Justice Lukert pointed out, we're not talking about reasonable doubt and what they have to know and convicting him. This is a probable cause finding. And based on the factors that were eliminated here as a different source for that odor, the only thing that remains is searching the last remaining source, which is that vehicle.
What remains is that what Justice Moritz suggested is that gives reasonable suspicion to extend the investigation, and as Judge Boozer says, all they had to do was flash their light into the car, and you have plain view.
Well, and the state would take issue actually with Judge Boozer's finding, because in Record Volume 4 on page 19, Deputy Gill specifically testified that he poked his head in and did not see anything in plain view. So the state would respectfully disagree with Judge Boozer's finding that there was absolutely no evidence presented that anything was visible in plain view. But as far as the other factors go, again, probable cause is not a neat, tidy set of rules.
Could you remind everybody what our definition of that phrase is?
Of probable cause?
Yes.
My definition is it includes all the information in the officer's possession and fair inferences therefrom to determine whether there is a fair probability that evidence of a crime will be found in a particular place. And it would be the state's position that where that strong odor is emanating from the vehicle and all other potential sources have been eliminated based on their contact with the defendant, that there is a fair probability that evidence will be located in the vehicle that he was transporting an open container. If there are no further questions, the state would respectfully request that the decision of the district court and the defendant's conviction be affirmed.
I think we're all on the same page, but I just want to clarify that consent and plain view are not part of this calculus.
That's correct.
Okay.
Any further questions of counsel? Thank you. You reserve 3 minutes for rebuttal.
Ultimately, what I think happened here is that the officers thought, because of the odor of the alcohol, when they testified that it was a strong odor, they thought that there might have been alcohol spilled in the vehicle. They may have suspected that there was an open container in the vehicle, but that suspicion does not rise to the level of probable cause to search the car. I'm not saying here that any time an officer smells alcohol coming from the interior of the car, there's not probable cause. I'm saying that in those circumstances, there has to be something more. There has to be other factors involved that would rise to the level of probable cause, but they're simply not present in this case. As Justice Moritz indicated, the smell of alcohol may have given them the ability to investigate further. They did that.
What about Ms. Isherwood's response that it's the absence of factors here that actually contribute to the existence of probable cause?
Well,
and in particular,
I'm sorry.
And in particular, the fact that the officer apparently did testify, he poked his head in and didn't see anything in plain view. So the absence of, essentially, he didn't see anything. He testified he didn't see anything. And we know he testified it's not emanating from this defendant. So it's testimony about the absence of factors that would explain this.
Well, if that's the argument of the state, that seems to run contrary to all the other case law that talks about we're looking for factors that are incriminating. And if we have an absence of factors...
Well, it's not an absence of factors. It's an absence of evidence that would explain it, I suppose, is what I'm,
Well, again, I think
way
that
I
runs,
get it.
that runs contrary. An absence of evidence doesn't weigh in the favor of the state here. It should weigh in favor of the defense.
Point was that it was an absence of evidence to support DUI, but not necessarily an absence of evidence to support the illegal transport of an open container. I mean, I understand your point that it's not absolutely illegal, but if the standard for probable cause is only a fair probability,
Well,
there was at least a probability.
I understand that. And one of the things she talked about was her officer poking his head in the car, which sounds an awful lot like a search to me, which would have been an illegal search, which I am arguing is what happened here anyway. The state has acknowledged there was no plain view, there was no consent, there was no erratic driving, there were no observations of the driver that were strange, and the fact that he doesn't have alcohol, the odor of alcohol present on his person shouldn't weigh against him. Yes, that may mean that the odor must be coming from the interior of the car, but the officers already knew that. That's nothing new. And just based upon this, I would argue that the decision here should be a reversal of the Court of Appeals and the District Court, that the state has not met its burden of proving that the officers' actions here were justified under the law.
Do we have any further questions of counsel? I see none. Thank you, counsel.
Thank you, Your Honor.
Thank you both for your arguments this morning. Court will take this matter under advisement. Now turn to the third case